Ready, start. This petition has been filed for a direction upon the UP Public Service Commission, Allahabad, to recommend the names of the waiting list candidates against the existing vacancies of assistant prosecuting officers, which had been advertised by advertisement number A5 E1 slash 1997 to 1998. Learned Counsel for the petitioners has submitted that all the petitioners had appeared in the written examination and were also called for interview. The final select list was declared on 20th March 1999, and even though the names of the petitioners were not included in the main select list, but they are hopeful that their names would be included in the waiting list. The state government had sent a requisition to the commission to recommend the names of the candidates next in order of merit, as certain candidates did not join the post, but the commission expressed its inability as the life of the waiting list had expired. The decision of the commission was challenged by 11 candidates by filing a writ petition in this court, which was dismissed. The Supreme Court, however, granted relief to them by directing that they shall be considered by the Commission and the state government and would be appointed if otherwise found suitable and eligible. The said decision was rendered in Shio, Shyam and others versus State of UP and others in bracket 2004 to ESC 256. The Supreme Court in the said decision held that the life of the waiting list, which is of 1 year, should be reckoned from the last date when the recommendation was made by the state government. However, in view of the fact that after the decision of the Commission not to send the names to the state government as the waiting list had expired, which decision was the subject matter of the writ petition before the High Court. The state government itself had sent a requisition of 56 posts, including 11 posts to which the dispute related, and examinations were held subsequently on 9th November 2003. The Supreme Court observed that the career of 11 candidates cannot be jeopardized, and therefore, in these peculiar circumstances, it directed that the appointment shall be considered by the Commission and the state government. Learned Counsel for the petitioners submitted that the same relief should be granted to the petitioners. From a perusal of the judgment of the Supreme Court, we find that because of the peculiar facts and circumstances of the case, that the Supreme Court had granted relief to the 11 appellants only. The Supreme Court could have granted relief to all the candidates in the waiting list subject to the availability of the vacancies. In the state of Kerala versus Kumari T.P. Roshana and others, AIR 1979 SC 765, the Honorable Supreme Court considered this aspect and observed as under: the root of the grievance and the fruit of the writ are not individual but collective, and while the adversary system makes the judge a mere umpire, traditionally speaking, the community orientation of the judicial function, so desirable in the third world remedial jurisprudence, transforms the court's power into affirmative structuring of redress so as to make it personally meaningful and socially relevant. Frustration of invalidity is part of the judicial duty. Fulfillment of legality is complementary. Selection of these 30 students will not be confined to those who have moved this court or the High Court by way of writ petition or appeal. The measure is academic excellence, not litigating persistence. It will be thrown open to the first 30 strictly according to the merit measures by marks secured. The same view has been expressed by the Apex Court in Ajay Hasia and others versus Khalid Mujib Shehrawardi and others AIR 1981 SC 487 and Punjab Engineering College Chandigarh versus Sanjay Gulati and others AIR 1983 SC 580 in Thapar Institute of Engineering and Technology Patiala versus Abhinav Taneja and others in bracket 1993 SCC 468. The Apex Court considered a case where the High Court had issued directions to admit the students who had approached the writ court, ignoring the merit of the students who had not approached the court. The Honorable Supreme Court observed as under. The High Court should have directed only 2 students to be admitted and that too on merit. Admittedly, there were more meritorious students than the respondents waiting in queue. The High Court thus travelled beyond its jurisdiction and not only directed more students than the institute could absorb but also students who were less meritorious to be admitted. No reasons whatsoever have been given by the High Court for exercising its extraordinary writ jurisdiction so peremptorily, which has resulted in injustice both to the appellant institution as well as to the students who stood higher in merit than almost all the respondent students. We refrain from making any further comment on the impugned judgment. Similarly, general directions were issued to give benefit to the students strictly in accordance with the merit in Shravan Kumar and others versus Director General of Health Services and others 1993 in bracket Supra 1 SCC 632 in KC Sharma and others versus Union of India and others in bracket 1997 6 SCC 721. A constitution bench of the Honorable Supreme Court has considered the aspect of giving benefit to a particular person and refusal to grant such benefit by the High Court to others similarly situated only on the ground that they had approached the court at a belated stage. The Apex Court held that in such a case, the judgment has to be rendered in rem and benefit of the judgment should be given to all other similarly situated persons. Stop.